Good afternoon, everyone. Thank you for being here. This is the third installment of the Stephen S. Kaufman Family Anatomy of a Trial lecture series. We've had two fantastic events leading up to this. This we expect will also be a fantastic event. We're so grateful that you joined us. We also are grateful to Steve, who is joining us here again. This was an idea that Steve had worked on for a while with Laura McNally, with Heather Lorenzen, and really wanted to share wisdom from those that were experienced trial attorneys with our students and, of course, with the broader legal. And we are so excited with how this has really taken off already. Steve is going to share a little bit about some of the great events that we have planned for the spring. But for now, please join me in thanking and welcoming Steve Kaufman.
Well, thank you very much, Dean, and Laura, and Jen Kupar, who's here, and Pete Wein, the last person on the lecture series committee. It's really been a lot of fun, and we're having a wonderful program tonight, which I'll say a few words about before I turn it over to Jen to do the introductions. But we really are looking forward to the spring. You know, this fall, we've had 3 different lectures that have covered soup to nuts on the trial of a case. And in the spring, we're planning it to be different. We're bringing in 6 different trial lawyers at the level that you've been meeting, but we're going to take a case problem and use it for the whole spring. And we're going to have each part of the trial in the same sequence as the fall, with a plaintiff's lawyer, a defense lawyer. We'll probably have a judge sitting up there, and they're going to do their thing. You're going to see a real demonstration of trial technique. And we talk about it this fall, and I know each of the speakers has done some vignettes and some demonstration, but the spring will be where the rubber meets the road, and we will show you each side of the case, how it works, and then we'll have time for conversation. So there's a lot more about that. We will announce the dates and the speakers and all that soon to come. Stay tuned. This continues to further the goal that I had in mind when I set this program up, and that I think you will see come out of this, which is to inspire a new generation of trial lawyers to want to study trial law, be a trial lawyer, and get to be an excellent trial lawyer. That's the whole idea, and we hope that for those that have been practicing for a while, you could learn things that will enhance your practice. So that's what this is all about, and I hope that you all have eyes opened and lights go off in making a career in trial law meaningful. So with all that said, I want to welcome Luke, who has been gracious to join us and be our third speaker this fall. Luke and I go way back to Thompson Hine before he went to the Wild West for the remainder of his career, and he's done an incredibly great job of developing and now perfecting a career. So looking forward to hearing Luke, and I know Jen is going to introduce him. So thank you very much, Luke, for being here.
All right, good evening, everyone. And one quick note before I introduce Luke, we'd love to have you stay after for a short reception and some mingling. We have a lot of students in the crowd who I know would love to meet some of the attorneys who are here with us. It is my great pleasure to introduce our speaker for the evening, Luke Dauchot. Luke is a partner at Kirkland & Ellis, where he focuses on patent and complex commercial litigation. He's tried many civil jury trials, obtaining some of the highest jury awards and venues throughout the country. Luke's consecutive jury trial wins for Samsung in 2015 earned him recognition by the National Law Journal as one of its 2016 IP trailblazers. And his earlier victories, 2 verdicts totaling more than $170 million in a single year, cemented his reputation as one of the nation's top patent trial lawyers. A fellow of the American College of Trial Lawyers, Luke embodies the highest standards of professionalism, ethics, and civility. He's an alum, and he also serves on our law school visiting committee, and we are so very grateful for his continued engagement with our students and our community. And I've had the privilege of seeing Luke teach, and Wennels, I'm going to tell you right now, I may or may not have given him your memo, too, that you worked on in the fall, and he may or may not be putting you in the hot seat later on this evening, so stay tuned, and we'd love to have your input. We're fortunate to learn from Luke's deep experience in that pivotal moment when the facts and testimony come together, the closing argument. Whether you're a practitioner refining your craft or a law student completing your first semester of law school, this session promises valuable insight from one of the very best. Please join me in welcoming Luke.
All right, well, good evening / afternoon, everyone. Jen, thanks for that kind introduction. Steve as well. And Dean Rose, thanks for the support of this important program. And I certainly appreciate it as an alum. So let me start with a reflection. I never in my wildest dreams did I think when I was a student, and we have raise your hands if you're a student. Wow, okay, we got lots of them. Never in my wildest dreams did I think that umpteen years after graduating from this law school, I'd be back in front of you all, the dean, and a number of distinguished professors and distinguished attorneys, to pass along to you all some of my experiences as a trial lawyer. I just, at the time, didn't have the confidence. But there was someone at the law school who did have confidence in me, and his name was Professor Jim McElhaney. And I'm going to share this story, and there's a point to it, hopefully. I was riding the faculty elevator up one morning, and it was interview season, and I was despondent. I could have wallpapered my bedroom wall with rejection letters from law firms. I just wasn't getting many bites. Part of the problem was that I was an okay student, but not top 10% of my class or something like that. And so McElhaney looked at me and said, "Dauchot, why are you looking so grumpy?" I said, "Well, Professor, just a lot of rejections, and the last one really got me." "Which one?" Baker McKenzie said no." "Baker McKenzie, Dauchot? What's wrong with those guys?" Like, "I don't know, Professor. Get back to me at the end of the day." I did. And Jim told me that he picked up the phone and secured an interview for me, but just a test interview for the firm to see whether or not it was worthwhile to bring me back for a full round. So at 2 in.the morning, I drove a rental car because my beat-up junker, I was afraid, wouldn't make it to Chicago from Cleveland. On, was it Highway 90 that takes you to Chicago from Cleveland? And I was listening to the radio, 2 songs in particular that I remember: Aretha Franklin, Who's Zoomin' Who, and Aha, Take Me On. I remember those were the songs that stick in my head. Got to the Loop at 7:30 in the morning, changed in my interview suit, took the elevator up to see a partner named Pete Moan at Baker McKenzie. And the rest is history. I got a job at Baker McKenzie, thanks to Professor McElhaney. And so 2 points to the story. The first one is, look, make it easy on yourselves. If you want to avoid the 2 a.m. rides to Chicago, do well in class. All right, that's point number one. Point number two, if things don't go quite as you want them to, have some perseverance and grit. And that is critical to be a successful trial lawyer, because in a trial, nothing or not everything will go as planned. Let me put it that way. There will always be surprises, heartaches. You're going to have to dust yourself off, pick yourself up. That's the second point. And then there's a third point, and this goes to the law professors who are in this room, and the deans. you can and do make a difference in people's lives. I would not be here where I am today were it not for Jim McElhaney and a number of other law professors at Case who took me under their wings, and despite my juvenile tendencies, and who believed in me and created, in significant part, who I am today. So thank you. All right, with that, let's turn to closing argument. Now, you'd think that closing argument is key, right? Because jurors, after all, are instructed early on in the case, the second that they're sworn in, the preliminary instructions, that they are to keep an open mind throughout the trial and reserve judgment until the very end. So it goes to follow that closing argument is absolutely key, particularly given this instruction. Now, what's the reality? Most of the trial happens before closing. And what's another reality? Jurors are human. This is a human exercise. They do form judgments well before close. In fact, some instructions require them to form judgments despite the one we just saw. They're told ahead of trial that they're supposed to assess the credibility of witnesses, right? They're supposed to make judgments. And they do. So here's another bit of reality. When these jurors are making the judgments, forming the judgments during trial, they are doing it in a fog of sorts. Now, what do I mean by a fog? What I mean by a fog is that they are getting just a ton of facts over a very short amount of time. A lot of it is jargon. A lot of it is beyond, way beyond their technical expertise. On top of that, the communication happens through this thing we call rules of evidence. And that's hardly an optimal way of communicating, right? I mean, can you imagine at a cocktail party trying to communicate according to the rules that govern attorneys and witnesses during trial? They have limitations in attention spans. They grow tired. They grow bored. Okay? So they are operating in a fog of sorts. To be sure, in some of the simpler cases, and by the way, I've tried all sorts. I was explaining to Dean Rose, I started off in Cleveland defending the railroad, Conrail, it was then called, I don't know if it's still called that today, defending CEI, the utility company, and then dealing with contract cases, then dealing with patent cases and trade secret cases, but all sorts of cases. And yes, some of them are simpler than others. But you have to plan for the confusion. You have to plan for the cloudy skies. Maybe it will be sun. Blue skies. Don't bank on it. So here's the reality that confronts you when you're standing up in close. Number one, you're dealing with an audience that's already formed a lot of judgments. And what do you want to do? You want to be running downhill. You want to be preaching to the choir, don't you? Or at least a group that's willing to be converted. What's the second problem? The second problem is, okay, Luke, I'm going to try to preach to the choir. But how are you going to go about this conversion process when the judgments are being formed in a fog? How do you go about that? And the answer is, be the brighter beacon in the courtroom. And I'll explain what that means. Before I move on, let me explain what you're going to hear it's not a textbook that I got from someone saying, hey, this is how you try a case. What I did after doing it for close to 40 years is I went back and thought, why is it that I've done pretty well in this business? What are the common things that I do, the consistent things that I do from case to case to case that seem to work? It's been a reverse engineering of sorts. And so what you're getting today is my sense of why what I've done works. And I've seen it validated through others as well, by the way. All right, so what do I mean by the brighter beacon? What do you require for a beacon to work? Two things. You need a light source, right? And you need an intensification mechanism, mirrors, whatever. So if you use this metaphor, think of the light as the nuts and bolts facts, the basic facts. For any one of you old enough to remember Dragnet, just the facts, ma'am. If you're not that old, don't worry about it. And then the other bit is you want that light to be intensified, right? You want the way you communicate those facts and the law to be more persuasive to a group of jurors than the opponent's presentation. Now, how do you do that? All right? You take the core facts and you take the law and you communicate them with credibility, with themes, and with tools. Okay? I'll get to what I mean by that. Credibility. Helping the jury believe you. Two components. You have the messengers. The messengers, witnesses and lawyers, need to be measured. They need to be honest. They need to be consistent. I'd probably add reliable up there as well. They need to be reliable. As a complete aside, every single case that I've tried, every single one of them, I've worn the same suit, day in, day out. It's a navy blue suit, it's a white shirt, and it's a darkish red tie. Some say it should be blue. Without fail. Some jurors over 3, 4, 5-week trials have come up to me at the end and say, Mr. Dauchot, can't you afford more than one suit? All right, well, I've got a number of dark blue suits. All right, now for the message. When we get to the message, two things really. What you say and what your witnesses say has to be true. It has to be supported by the record. And in trials, if the facts aren't in evidence, they may be true, but they don't exist, right? So they have to, what you say, what the message has to be what the record provides. Okay. Second thing is it needs to be logical. It needs to make sense. Okay, now you could ask me the question, well, Luke, what happens if the truth in the record doesn't make sense? That's another class. But true and logical. And we'll touch on that a little bit later. All right. Note, anybody ever heard the adage, you don't need to outrun the bear? Raise your hand if you have. Right. So if your friend are getting beat, there's a bear that's chasing after you, you don't need to outrun the bear, right? You just need to outrun the person next to you. And so it's the same thing with the credibility point. You don't have to be, not everybody has to be Mother Teresa up there, all right? You just have to be more credible in comparison to the other side. And where I'm going with this is, and you have to play by the rules, absolutely. But exploit opportunities to test the credibility of the other side during trial so that in comparison, you're the brighter beacon. I'm not going to say try to trip them up, because that conjures up a lot of things. But you need to exploit mistakes on the other side, particularly when they come to credibility. All right. Themes. Okay. Now, I think you heard Mark Lanier, the first speaker, talk a little bit about themes. Folks, they are absolutely critical in a trial. A theme is a concept that is going to have the jury root for you. Okay? What is it? It's a lens through which you invite the jury to see the evidence presented, be they witnesses or documents, and that lens creates a sense of equity and logic. Okay, that's what a theme does, and we're going to get into in a second how to build a theme. Anybody familiar with this problem? Raise your hand if you are. I hope a lot of you are. First years, this is your problem. Okay. All right, and I'm going to bring everybody on board here. These are the facts of the case. The 1Ls are working on this. There's a company, and this is Timberline Public House. It's founded in 2020 by twins and a kid named Carlson. The twins are from a very wealthy family. They put money into the business, but Carlson can't. And so what he does is he brews beer and he provides sweat equity. 2020, the twins put up a contract for Carlson, employment contract. He gets $60,000 a year. There's a work for hire. Everybody know what a work for hire is? Whatever he does, whatever he invents, whatever he conceives, belongs to the company. I mean, it's not quite accurate, but it's good enough for what we're doing today. Confidentiality agreement. He's not going to pass along to competitors what he's doing. Non-compete. He's not going to compete for a limited amount of time. And the contract was drafted by the twins' brother, who happens to be in law school. I think he's a 1L. 2021 to 23, the business grows. The twins manage the business, and Carlson develops the beers. 2024, this is where it starts getting interesting. The twins go to grad school, leaving Carlson behind to run the company on his own and keep building it. And that he does. A competitor is working on an improved beer. Hopped as Wisconsin Pine, we'll get to that. Okay, Pine Lines, what Carlson creates, beats the competitor in a contest. When that happens, business for TPH explodes. What do the twins do? They ask the family for more money. They pour more money into it. What is Carlson doing? The brewer, he's talking to a distributor to try to get that distributor to distribute more beer, to create more business for the company, more money. Uh-oh. Right in the middle of Carlson's discussions with the distributor, he decides to jump ship and go to the competitor. And lo and behold, the competitor comes out with this brand new beer. By the way, the distributorship, TPH was just on the verge of getting it. They never got it. So there's a lawsuit. Okay, we have, hold on, let me go back here. That's the thing with these builds. You got Timberline versus Granite Shore. And think about Granite Shore as Carlson. Question for the group. Can you come up with some themes? You represent Timberline Public House. The twins. Some themes. I asked somebody to have you think about this in advance. I created some, and we're going to hit them up. We're going to touch on them and close. But any thoughts about a good theme here? You're going to trial. You're supposed to paint Granite and Carlson as bad actors, and Timberline as a good actor. Any themes come to mind?
Disloyalty.
Disloyalty. All right. Any others? Betrayal. How about granite? And I'm writing this down for a reason. We'll revisit it in a little bit. How about granite? Give me a good theme. David, a good theme for granite. Come on.
Free market competition.
Free market?
Competition.
Competition. Any others? Okay. A theme, okay, is not a statement to the jury about we should win. Okay, I asked a partner of mine, actually a pretty accomplished trial lawyer, I said, what's your theme in a patent infringement case? He said, we don't infringe. That's not a theme. That's your conclusion. What's the pitch going to be to have this jury process, see the facts your way? A theme about disloyalty is certainly one way to do it. A theme about betrayal is certainly one way to do it. Competition, that's another way. Those are themes. They're important. And what you do through your trial, you raise the themes in your opening, and then you have them echoed through the trial for you to revisit them in close. It's really a seamless process. Okay. I didn't foresee this problem, but here we go. Tools. What are tools? Processing facts and law is hard. Right? Can you imagine you're sitting in a jury box and you're listening to lawyers and witnesses drone on for a week if you're lucky, maybe 2, maybe 3. I've had one run as long as 6 months. How is the jury going to process all of this stuff, the facts in the law? I liken it, anybody ever tried to put together an outdoor grill? Like a real fancy one? I have. I mean, it's difficult. It's impossible to do. Imagine doing it without any instructions. That's what you're asking the jury to do, without giving them tools to process the facts in the law. You're asking them to assemble an outdoor grill or think about a complicated piece of machinery without as much as an instruction manual. As they're sitting there at trial trying to figure out how all this stuff ties together and why it's important and how it all fits together, right? Okay. You need to give them a toolkit. And what's that toolkit? Let's begin with narratives. Anybody here from Mark Lanier's presentation? I thought it was excellent, by the way. But much of Mark's presentation was about narratives, okay? Creating stories that helps jurors process and recall facts. If you put them in the context of a story, an interesting story, they'll remember the facts. Let's see how compelling my story was up front. Who remembers the 2 songs that I was listening to at 2 a.m. driving to Chicago from Cleveland? Dean Rose? Who's Zooming Who? And Take On Me. Anybody remember what time I pulled into the parking lot in the Loop? Yes? 7:30 in the morning. Anybody remember the law firm? Baker McKenzie. I suspect that if I had just sat up front and given you the facts, first job interview, Baker McKenzie, in my car at 2, got to the Loop at 7:30, and just left it at that, turned on the radio, heard a couple songs, boom, 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 you probably wouldn't be remembering it as well. I'm not going to go over what Mark did. He did a heck of a job doing it, But that's why narratives are important, okay? So, Timberline and Granite Shore. If you're Timberline, let me go back here. If you're Timberline, what's the story about? Just start the story that you're going to tell the jury. This is a story about what? Betrayal. It's a story about betrayal. And then you start building into the story, right? On such and such a date, the twins and Carlson got together, and you start building on that, and you tell that narrative. It's a narrative about betrayal. What about Granite? This is a story about. I already put some together for the close, the actual close, so we'll see. But some of it tracks what you're all coming up with. How do you start if you're representing Granite? What do you say? This is a story about what? That's going to start capturing these jurors. Thoughts? It's the harder one. All right. Well, I'll let you in on mine when we get to the closing. More tools, how to put the laws and the facts together. I'm not going to go into any detail here, but one great opportunity to show the juries how to piece the law and the facts together is through what we call expert testimony. In trials, we have experts who come in and provide opinions. Their opinions have to be relevant, meaning that they have to advance some question, some answer to some question that the law requires to be answered. And so that's a good point of intersection where the expert can talk about the law and how it fits in with the facts. To a degree, judges are extraordinarily vigilant about anyone trespassing on instructions of law. And for good reason, they should be. But there's a way to do it. The other way to do it is through closing argument. Okay, and I'll touch on that. So that brings us to closing. We had the goals, right? You want to be preaching to the choir, okay? And you want to deal with the fog. You want to be that brighter beacon. And so you want to be that brighter beacon all the way in through deliberations, where this jury understands the credibility issues, the thematic points, the tools that you've given them, and they're drawn to your side. It is a critical dynamic, particularly in a complicated case. I've tried lots of simple ones, but I've tried some of the most complicated that the system sees. When we're talking about patents and all sorts of technology that, I shouldn't say this, it's being taped, that I probably still don't quite get. But the point is, the jurors need to have this innate sense that you're right. They want to go with you. Okay? So, how do you start the close? You understand that's the mission in closing when you start your trial. And so you've set up during the course of trial these elements. And now it's payoff time. You're standing in front of the jury in close, and you begin by reinforcing the themes and the narratives. Let's go with themes. This was a patent case that I had. Note how I started. I explained when we started this case. That's the first thing I said, pretty much standing up for my close in this case. Okay? Patents properly used are good. Okay? When they're misused, they're abusive, they're corrosive, and they can do a lot of harm. And what we have here is abuse, a corrosion of our patent system. People stretching this patent to cover stuff for nothing more than, millions of dollars at the expense of the integrity of our patent system. Okay, that's how I started that one. Timberline. So I'm representing Timberline, right? And this is what I created as a theme, by the way. I heard it earlier. I explained when we started this case, members of the jury, we've all heard of inking a deal. Why isn't it called penciling a deal? Well, actually, this is a different one. Nobody raised this. This is on the contract issue. That's because a deal is supposed to be a deal, right? They signed a contract with Carlson. It can't be erased and manipulated to change the deal because Carlson didn't like it. And he thought he could put a better one on ink. Carlson believes in pencil deals when it came to what he had to do, like not compete, keep his mouth shut, right? But he believed in ink deals when it came to what the twins, the sisters, had to do under the contract, which is paying his salary and funding the business. I'm not saying this is a great one, but it's a theme. Contracts are inked. They're not penciled. Carlson just can't walk away from his contractual commitment because he happens not to like it. Okay, now we're on the Granite side. Okay, you got Carlson. How about this? I explained when we started this case, contracts are not supposed to be traps. A ruthless device crafted by a lawyer that catches the unwary who have no chance to afford a lawyer. You've heard of folks bargaining, give and take. Both sides pushing and pulling with eyes wide open. That's what a contract is. Not what we have here. The twins and their lawyer brothers saw a gold mine in Carlson, and they got a gold mine in Carlson. They trapped him all to themselves. Okay? Contracts aren't supposed to be traps. It's supposed to be even-handed bargain, a level bargain. Okay. How about the narrative? This is an actual case I had. Okay? A plaintiff sends letters to 8 companies demanding that they cease infringement of a patent by paying for a license. Okay? They did very, very limited technical due diligence when they started. 8 of them agreed to pay, albeit for a relatively low sum. The client, a big multinational corporation, doesn't. It gets sued, okay, for tens of millions of dollars. The plaintiff's theme, my client, was arrogant, greedy, and disrespectful of the little guy. The proof? Hey, you had 8 others, companies, who decided to pay a license fee under this patent. What gives? Why does this multinational behemoth, why do they think they don't have to pay? That was the narrative, that was part of the theme as well. So here's how I dealt with it in this trial, and it wound up pretty well for us. And I'll let you read it, I'll read it out loud. We are here today, members of the jury, because a number of parties got demand letters from the plaintiff, and they got sued. And a number of those parties said, yes, we'll pay for sums. But these sums are what the plaintiffs are admitted to be significantly less than the cost of litigation. Now, other companies said, no, we're not paying. And my client was among them. Yes, we're big. The company I represent is big. My God, if I had a penny for every time the plaintiff's lawyer talked to the jury about how big my client was, that's why I did this in close. But being big is not a sin. And it certainly doesn't mean that we ought to pay $50 million to a company that sends us a demand letter to pay a license on the basis of accusations that aren't even supported by a product analysis. The issue, members of the jury, is misusing patents to collect money on the basis of accusations and allegations that aren't there. It's a shoot first, ask questions later mentality. Shoot first, ask questions later. Okay? The reason I use that was people know what that means. I wanted that to stick in the jurors' heads when they were deliberating in the jury room. Were these plaintiffs behaving like that? Shoot first, ask questions later. Now, we decided to fight, right? I have to justify that. So here we go. As if we're all supposed to pack up our bags and go home because we had 8 or so companies decide that they'd rather pay a relatively small sum of money than putting these patents to the test. That was the concept. Okay? And it worked. All right. Back to Timberline and Granite Shore. Narratives. Let me start by look at the, before we jump in, we have a little bit of time here. I'm actually way ahead of the game, which is good for me. I'm not so sure about you all. But so we have Timberline, right? The theme, wealth traps genius. Okay? Actually, that's not the theme. That's the narrative. I jumped ahead. But look at this first. Come up with a narrative for me. Come on. We have some time. I built this into the presentation. What's a compelling narrative here for Timberline? No takers. Jen, they haven't changed. Last time I was in your class, you're saying they were busy studying for an exam.
They are right around the corner from exams, and they're working on...
No, that's all right. I'm kidding. Somebody raised a hand. Oh, no, that was creep. You don't have an idea, Christopher? Okay, no idea. Any ideas? Yes. Yes.
This isn't a case about simple disloyalty. It's about someone stealing the most essential aspect of your company, destroying the trust you have in them, and running to another who say that they can do their job better than you.
I like it. I like it. Anybody else want to give it a shot? This is a story about something that is just going to make this jury feel, when they're deliberating, that it makes all the sense in the world to go your way. Yes?
Timberline didn't trap genius, they invested in it. They gave Kaufman the chance to work and build this company with their support into an award-winning beer, and now they decided to turn around and throw that away and throw away that support for what they think is something better, and it's disloyal.
Disloyalty. We keep hearing that. Thank you. Yes?
About deception and theft.
Deception and theft.
Yeah, you got that with Carlson stealing the opportunity.
And where does the story begin? Where does the story of deception and theft begin? What's the first step of the narrative?
First step is that you've got Carlson stepping out of the office for a minute. They give him an opportunity, and Carlson then steals it. He has that opportunity, and then he goes with it.
Might the first step, if we say betrayal, why is there betrayal? Where do you start the story? Why is there betrayal? In order to have a betrayal, you need
Reliance.
a trust that was given, or it's really not betrayal. Doesn't it begin at the start with the contract? The three got together, that's where it would start. All right, let me show you what I put together, and let's see if it makes any sense. Timberline. This is a story of trust and betrayal. 3 college kids with dreams. Dreams about opening up a brewery. The twins could put the dream to life by asking their family to invest in it. Carlson chose to invest by brewing. He asked the twins to trust his brewing skills and trust him. And he agreed to put that in writing. In ink, members of the jury, not pencil. The business relied on Carlson's skills and loyalty. And they paid him for brewing. And it needed Carlson to be loyal. Timberline needed Carlson. Over time, the twins poured more and more money into the business, counting on Carlson to stay loyal as the business grew. Just as the business peaked, Carlson betrayed the business and betrayed the twins. That's one narrative. Okay, let's put on Granite's hat. This is a story of wealth trapping hard-working genius. You had 2 wealthy college kids who saw a huge business opportunity in their friend Carlson, a brewing genius. They wanted to bottle that genius. I know, I'm switching up metaphors. Bottling the genie, get it? Traps, but all right, I digress. And so they enlisted their law school brother to draft a trap they call a contract to keep the genius in line. Carlson worked alone and like a dog to make Timberline a success, while the twins went on to graduate school and mailed in checks from their mom and dad. Over those 5 long years, and as Carlson made Timberline millions of dollars, Carlson never even got a raise, members of the jury. Not a penny. And when Carlson said enough's enough, the wealthy twins sprung the trap made by their lawyer brother. That's another narrative for the other side. And so you see the jury's going into the liberation room and they're going, okay, you know, you got the twins putting their trust in Carlson. Carlson getting paid a salary, Carlson betraying that trust as they had their family pour millions of dollars into the business. That tugs at a jury's sense of logic, common sense, fairness, equity, right? And then you got the counter narrative. You have a guy working his tail off who doesn't have the money to invest or the money to hire a lawyer for that matter. He creates millions in revenue for this company and he doesn't even get a raise. Didn't have to give him a raise. That's the way the contract was written, the trap. Okay. That has some pull as well. And by the way, this is an entire different course, but that's why when you pick a jury, you have an idea of these narratives, both of them. You got to think about where the other side's coming from. And when you're picking your jury up front, you're starting to think, what type of personality traits, what type of life's experiences are going to lend a jury to accept, to feel more drawn to one narrative versus the other. I mean, that's how it all fits together. Okay. Once you're done with the reinforcement of the themes and the narratives, you now proceed in your close to the essential facts that support them. We've obviously touched on some in the narrative, right? But here's the trick, all right? A narrative it's factual, but it's argumentative, right? I mean, you heard me. And so jurors will always take what a lawyer says, no matter how eloquent, and sometimes the more eloquent the lawyer is, the more their guard comes up. But the point is, the jurors they get the narrative. If you give them the facts, or they understand the context, the paradigm in which you want them to fit those facts, right? But they want to hear the facts. They want to hear them. And so now what you do, the next part of your closing, after you've reinforced the themes, reinforced the narratives, you now start marching through the essential facts. Okay? We said that this is a story about trust and betrayal. The story begins. Boom. 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 And you start going, and we're going to go through the timeline again. And I'd like to hear some of these facts from you all. And by the way, there's this thing called the burden of proof. Now, I'm not a criminal lawyer. But a big distinction between criminal cases and civil cases is the burden of proof. Most issues in civil cases not all, but most are decided by a preponderance of the evidence standard, which is a scale, right? And if it tilts just a little bit down, you've won. But just a little bit. Okay? Criminal cases, it has to be substantially more. It reminds me, and I'm not going to mention the lawyer, but I learned a lesson watching this. I was in the gallery. A brilliant trial lawyer was giving closing argument. And at one point, he ambles behind plaintiff's counsel. So plaintiff's counsel doesn't see him. The jury box is in front. Plaintiff's counsel's table is right here. He scoots behind him. And he says, "Now, members of the jury, the plaintiff has the burden of proof by a preponderance of the evidence." I almost laughed out loud. Okay? The judge wasn't paying any attention. But the plaintiff's lawyer wasn't paying any attention either. And so some of you may not be following, but the actual burden of proof is like this. It ain't this. Okay? But that's what he did, by a preponderance of the evidence. He darn near fell over as he had that scale dropping. It was a riot. And I observed and I learned a lesson from that I never forgot. And I said, never, ever, ever keep your eye off opposing counsel, particularly during argument or opening statement for that matter, or voir dire. All right. But here's the trick with burden of proof in civil cases. We have, I've heard it said a lot, and I believe this. If you're going to start yapping in a civil case about how you should win because you have, you don't have the burden of proof, the other side does, you have a pretty weak case. You just don't. In a civil case, it's just too close, right? Okay, this reminds me of a very accomplished plaintiff's lawyer in Chicago. And he kept talking in his closing about the burden of proof and explaining to these jurors that to win the burden of proof, all he had to do was tilt those scales in his favor by just a feather. A feather. Think about it. I'm sitting there ready to respond. I said, a feather. Is that all he has to his case? A feather? Right? And there lies the trouble with bringing up the burden of proof in a civil case. I told the jury when I stood up, that's actually where I started. I picked up, I said, well, I won't mention his name. Mr. So-and-so does have we do agree on the weight of his evidence. Members of the jury, that we agree. And I got that reaction from the jury. It doesn't weigh a heck of a lot more than a feather. And someone whose best thing he can say about his case is that it outfeathers us has a problem. Okay? So I relay the story because it drives home the point that when we start talking about burdens of proof, particularly in a jury trial, it's very defensive. In a civil case. In a criminal case, I think it's a completely different equation just because it's such a huge difference. And I might add, there may be cases where you have to bring that out. If it's a really close call, and I can't conjure up facts right now that would make me very comfortable to make a big deal about the burden of proof in civil cases. And let me add something here while I'm at it. You're hearing some of my perspectives and some of my opinions, right? The beauty about the practice, trial practice in particular, is that, look, the way I think about it is, we're artists, we're craftsmen, and we have this canvas to work on, right? Now, the canvas is bounded by a frame. We call that the law, rules of evidence. Rules of procedure in a courtroom, what you can, the way, rule against leading questions, et cetera, et cetera, et cetera. But boy, oh boy, within that frame, you got a canvas and it leaves room for all of your imagination, different angles, different tactics. That's the beauty of the practice. It gives you that room for artistry. And so, as a consequence, you're going to hear a lot of different trial lawyers say different things about the way they approach things. I heard one speaker talk about discovery as a complete example. He said, well, when I take discovery, I don't want to ask questions. I'm going to tell the witnesses what the answers are. Okay? I have a completely different view. I don't know if you remember that comment. And I'm going off on a tangent here, but just to point out the example. When I take discovery, okay, as a rule, sometimes there are exceptions, I want the witness to yap, talk. The more emotional, the better. Because the more emotional they get, the more stuff comes out that I'm maybe going to be able to use. I had a case here in Cleveland. I think it's the last one. That's when Mr. Hooker over here was my boss. I took a deposition. This was a government entity against a construction company. All right? And we weren't getting paid. And the government entity was saying, well, you screwed up. You didn't do this on time. You didn't do this on time. You didn't do this on time. It cost this. Blah 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 blah. We said it was all pretextual. It was nonsense. And I took the deposition of the owner's representative for the government entity. Okay. Look, to call him a hothead is the understatement of the year. This man had a legendary temper, and I knew that going in. And so, what am I going to do as a trial lawyer taking a discovery deposition to get some good stuff on the record? I want to get the hothead to get hot-headed, right? You never know what he's going to say. Well, he delivered. He delivered. At one point, I got him so bloody mad at me. He looked at me. He pointed his finger at my face. And he said, listen, Dauchot. I think he botched up my name. At the job site, I am judge, I am jury, and I am executioner. I mean, fast forward to trial. He's on the stand. My cross-examination begins. Now, Mr. So-and-so, put it to the jury. He said, as far as you're concerned, you're the jury. Am I correct? I didn't say that. As far as you're concerned, you're the judge. I didn't say that. In fact, as far as you're concerned, if there were a death penalty in these cases, which thankfully there aren't, you'd be the executioner. I didn't say that. Boom. Impeached him at trial. Fast forward to closing. As we're going through essential facts and essential credibility issues, and as we're starting to think about themes and narratives. This is a long-winded way of saying, because I have some time, to say that when you're taking depositions, and someday you'll all be taking depositions, ask the questions. You never know what you're going to get from these witnesses. At some point you have to start focusing on all that. But ask. Ask. Okay. Credibility issues as well. After you're walking through your essential facts, remember, members of the jury, that, boom, boom, boom. I've used the line repeatedly if you go over transcripts. Members of the jury, if I had, a dime, well, actually I have to use a better, if I had $1 for every time I had to impeach someone in this case, I'd have enough to buy myself a pretty good meal tonight. And then you put up and you go through the impeachment, and you go through the impeachment, and you go through the impeachment, and you go through the credibility. And he said this, and he said this, and he said this. And you do that after you've laid out your theme, your narrative, and the key facts that support it all. Because once you've done that, folks, you now have your house in order as this jury is about to go deliberate, right? And now what you want to do, in a sense, is go on the attack and make the point that whatever it is that they're saying, and if you're going first, don't believe a word. All these credibility issues. If you're going second, to the extent that they scored some points, and you'll deal with them, same point. They can't be believed. Are you following the logical order here? Okay. And by the way, someone was asking me before that, do I have a template for these things? Case, case, case. This is about as close to a template as I have. And I tend to stick by it. This thing right here. And I'll get to validation and response in a second here. Okay, now I'm making you all dizzy. Okay. All right. So we've got the credibility issues, and the point is you want to dirty up, for lack of a better word or phrase, the other side. You want to take the shine off that, okay, of what they present, and you attack it through credibility issues that you've set up during trial. Now, let's talk about filling out the facts for the narrative. Okay, Timberline. Right? We've got the story, the narrative of wealth-trapping genius. Okay? Actually, that's not Timberline's thing. Let me see. Oh, I had it backwards. I knew I'd do this. Timberline is trust and betrayal. Here. Pretend that says Timberline. Trust and betrayal. Okay? I knew I was going to do this. All right. That says Timberline. Trust and betrayal. If you're going to fill up in your close some key facts, given that your narrative is about trust and betrayal, where are most of your facts going to be coming from? Okay? You're going to pull the facts from the trust building process, the helpful facts in the case about how these two twins were going to rely on Carlson to do something, and how they decided to pour money into it, or their family. Okay? So you're going to build up, right? This is where you're going to build up a lot of facts. And then on the betrayal part, your facts are going to come out of here, right? You see that? How that works dynamically? All right. Credibility issues. as you start throwing stones at granite. Okay? Where do you think along this timeline you're going to have a lot of opportunity to start raising credibility issues, build up impeachment, get the other side defensive about what really happened? Better yet, get them lying about it. Where? Where's that going to happen in this timeline? Yeah. Jill, right? Yeah. And somebody else in the back? Where in this timeline are you going to have a whole lot of fodder for credibility issues? Yeah. 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 Right, exactly. Because Carlson's going to want to take the position, hey, I was a perfect innocent. You know, up to the moment I left, my loyalties were 110% behind Timberline. Really? Right? That's right. That's where you're going to get the credibility shots. Okay? So the factual development up front, the trust building, the betrayal. Now, let's turn to Granite. Sorry, Timberline should be Granite. Wealth traps genius. Okay? Where are you going to get your facts from? Where as you pull the facts to make the, to build up the narrative, or once you've had the narrative, what key facts? Where are you going to find them? Up front, right? The contract formation. Carlson's not a lawyer. I mean, look, with all due respect for people who brew beer, all he does is brews beer. Getting ambushed. He's got this contract to sign, and to him, $60,000 a year is a lot of money. Okay? So you're gonna focus on that. What else are you going to focus on factually? How the twins did what?
They left and went to grad school and stayed behind.
And you hit the point at the end. The 3 words. What were your last 3 words? All the work. That's what you're pounding on. The genius and the work. Hard work and genius. And you just pound, 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 to the point where the jury feels guilty about enforcing this contract against them. So to speak. I mean, the jury has to respect the law. But that's what you want. Guys working like crazy while those 2 kids born with a silver spoon in their mouth go off to graduate school. And heck, by the way, it wasn't as if it were their own millions. They went to mom and dad to write the check. Makes it even worse. I'm being an advocate here. Nothing wrong with wealthy people. But you follow me and you develop those facts. Okay? Credibility issues, where are you going to find them? If you're for Carlson, where do you think that the twins are going to get a little defensive?
When you talk about loyalty and disloyalty, where were the twins? Who was managing the company when the twins left? That's the disloyalty there. About disloyalty.
Yeah. Yeah. Okay. The contract. Okay. All right. When you're done with that, okay, when you're done building your case, all right, through the reinforcement of the themes, the narratives, you deliver the facts that support the narrative. You hit them with credibility. No trial is going to go well completely, flawlessly for you. You're going to take some shots during trial. Ignoring them is probably not the best way to deal with it, right? I mean, when you take a hit at trial, yes, when you're at counsel table, act as if you didn't take a hit. Just kind of, you don't want to act like you just got mortally wounded. But that said, when you get to close, don't wish that the jury forgot about it all. They probably didn't. And by the way, if they did, and you're going first, let's say, trust me, the other side will point it out. So you have to, now look, if it's truly trivial, maybe not. And it's not just a question of if it's truly trivial. The question you have to ask yourself as a lawyer making that judgment call is not, do I think it's trivial? Does the jury think it's trivial? Okay? But let's say we all agree. This is a relatively non-trivial point. Do you ignore it? No. You got to control it. You have to deal with it. Okay? Now, if you're up first, there's a reason why we put credibility or the response sort of in the back of the line, right? Because when you respond, what are you being, really? Starts with a D. Defensive. You don't want to stand up and close and get defensive right off the bat. Yours truly made that mistake as a very young lawyer. Again, I was working for Mr. Hooker. He wasn't in the courtroom, thankfully. But it was by far and away one of my worst closings. And the reason it was, and I admit it, we make mistakes. I did. And what it did is I was actually second. And I stood up, and all I was doing was reacting. Reacting. It's defensive. You don't want to do that. And so, two ways to deal with that. You don't get to the response unless it is such a mortal wound that it's the elephant in the room, everybody's focused on it, you know everybody's focused on it, and you have to deal with it. And you know how I deal with it in close? As I'm going into the reinforcement process, I make a note of the issue just to let the jury know I'm not going to ignore it, I'm sensitive to it, and then I say, but we're going to get to that if it's that bad. Okay? Because you don't want to lose what? You don't want to lose, starts with a C, credibility. You don't want to lose credibility. Ever. Okay. Now, whether you're anticipating things that, you go first, you're anticipating stuff they're going to say about weaknesses in your case, or you're actually second, reacting to what they said up front, you have to deal with it, okay, as, in an affirmative, if you will, in an offensive, not a defensive way. Okay? And there are only two ways that I've consistently been able to do that with a good degree of success. Either I take what they say and I say, look, this is actually desperation on their part, and it's actually helpful. I try to frame it as something that actually supports a position of mine, okay? Or I call it a distraction. What do people do who don't have anything to say on the merits? They distract. They come up with all sorts of stuff. Throw it all up on the wall. See what sticks. Right? Jurors get that. Cast your weaknesses or what, some of the punches that have landed that way. There may be other ways to do it. I certainly don't have a monopoly on, look, for that matter, good ideas, period, but certainly not when it gets here. And if you have good ones, pass them along. All right. So that's the respond. Now we get to the last part, and this is called validation. I've been talking quite a bit about getting jurors to feel like you should be the party winning. Just, there's a logic, there's an emotion to it, there's reason to it, they're drawn to you. Okay? But you are going to make a big mistake if you ignore the law. I've seen this at work time and time and time again. Lawyers who stand up there, and it's not just that they're all flash, okay? It's that they expect to win on the basis of emotion. And look, obviously, pour an emotional component into your message. We're humans. You want their emotions working for you, right? But don't exploit them. Don't make it only about emotion. Because if you make it only about emotion, one of two things, or maybe both, are bound to happen. Number one, you're going to turn the jury off. The jurors want to know, they want to know that what it is that they intrinsically feel like doing for you is the right thing to do. That what they're feeling is right by the man or the woman wearing the black robes. They want to feel that way. And so, to focus on the front end, to get these people feeling like you should be winning, and that is a critical part of the process. Why? Because someone who feels like going your way is more likely to do so than someone who feels neutral, or worse, doesn't feel like going your way. That's why you want to get the feeling component. But that's not the end of the job. You have to validate the feelings. And I mentioned earlier, this is part of the tools, that you can do some of that through expert testimony, and I'm not going to get into expert testimony, but you can do it through close. In closing argument, usually these days, and I think that practice has changed. When I started, they tended to instruct the jury after the closings. Now most of the judges do it before the closing. So you know what the rules of the game are going into your close, right? And you have to, so in your close you have the instructions. You walk the jury through the instructions. It sounds boring, right? That's not the stuff of, Perry Mason and flashy trial lawyers to, put them through instructions and the like. No, it's critical. Because what you're essentially saying is, okay, you're in my camp now, but I want you to get you in the judge's camp too. What I'm asking you to do is right by the judge. It's what the instructions compel. And that is, by the way, why I wrap up closings with the validation process. That's the last piece of it, okay? Now, in addition to validating what they're feeling, is you got to have a tool to help them. Has anybody ever read instructions that judges read jurors? I mean, call them what you will. They're not a model of clarity. Okay, and by the way, judges will agree with that too, but it's the way it happens. Some instructions are actually pretty straightforward, but in patent cases, instructions on the law of obviousness, instructions on the law of anticipation, oh my gosh, and they go on and on and on and on, and you're like, you wonder, who understands this? But it's the process. It's the process. What's actually an interesting twist here, when these cases go up on appeal, what does a court of appeals do? It assumes that the jury understood the instructions. Okay. So, it is left to us to deal with them. Now, tread very, very carefully. Now, as I mentioned, judges do you a favor, tend to do you a favor these days by giving the instructions beforehand. So that by the time you stand up there, you have them. And you can put them up, you can highlight them, but you have to be fair in how you go about working them. And there was a day where the instructions didn't come until the tail end. And then it got a little dicier, although there were ways to get, some clarity. But how do you go about dealing with, helping jurors understand instructions? Number one, if you're taking notes, write this down carefully. You do not want an objection during your close to get sustained, but misrepresenting the law is a surefire way to do it. Okay? So, we talk about patents. These are actual things that we use with the jurors. Okay? What's a patent? Okay? And in patents, and by the time the jury see this in close, they understand that your legal monopoly, if you will, in the patent is what comes at the back end, what we call the claims. They are the boundaries. Okay? And so what we explain to the jurors is that it's like a deed to land. A patent gives you land. The boundaries, okay, are delineated by the claims. We get to, this is just another example. What's infringement? Well, this is one that we've actually used. So you have a patent, right? Members of the jury, let's talk about the instruction on infringement. The court will instruct you that, boom, boom, boom. I'll put the instruction up maybe on an Elmo or something. But what does that mean? Well, if you have a patent on a soccer ball, the claims, a ball made of leather, stitched together, filled with air, and round. Now, to have an infringement, each and every element of the claim needs to read on the accused product. You have to find each and every element of the claim in the product that's accused of infringement. So, and this is a hypothetical we give them. We have a football. A ball, check. Made of leather, check. Stitched together, check. Filled with air, check. Round, no. And so, that patent does not cover that product. In other words, that product doesn't infringe the patent because it doesn't capture each and every single one of the claims. So that's one example of how we go about, in closing arguments, educating the jurors about the instructions. And then what we do is we pull out the actual patent, and I was thinking about doing that, but I'd have to start redacting a bunch of stuff anyway. But you have the actual patent, you have the actual claim language, and we color code it. Okay? And then we say, okay, this is orange, this claim is orange. Where do we find orange in the accused product? Check. You follow me? We explain, we help the jury get that accomplished. When we get to attacking patent validity, again, for prior art to invalidate a patent, each and every single element of the claim needs to be, anyway, I'm not going to go into all of but this is just an example of what it is we do in close to make sure to do what we can, all right, to have those jurors as well equipped as possible, i.e., we give them the tool to get to work on those instructions. Okay? All right. We may actually end a little early, Jen. All right. Mechanics. I was trying to synthesize it, and there's so many things at play in the mechanics, right? And I was trying to boil it down into a few points. And actually, the two that I came up was, number one, be inviting, and be authentic. What do I mean by being inviting? I mean be measured. It's interesting. When we have this program at our law firm at Kirkland, we train our associates on the mechanics of trying cases. And initially, a lot of them stand up and they're very, they are da-dee-da-da-da-da, and their hands are played da-da-da-da-da-da-da. It's like, and they're brilliant lawyers. And I'm actually talking about a few of them. We say, settle down. And actually, they take it to heart, and it's just tremendous how much better they do. There's this sense out there, this popular sense out there, that to be an effective trial lawyer, particularly in closing, you have to be loud, you have to be emphatic, and you have to always be loud, and you have to always be emphatic, and you need flash, and you need this, and no. At least, not as I see it, and I've never been that way, consistently. And I'll tell you why I say consistently. Because when you're trying to, you need to be measured. The jury needs to understand that you're in control, that you're reliable, you're measured. Now, and it's funny how we can do with our voice, right? So as I'm talking here, and I pause, and then I keep going, and I have a low voice, and then I pick it up, and 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 then back off a little bit, back off a little bit, back off. You see, that you don't always have to be 100% high energy, blah, 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 blah. Be cool up there. Be measured. Okay? You will appear reliable. Because highly emotional displays are typically perceived as inherently, I don't want to say not credible, but you're being emotional. Who's ever heard, if somebody says, gosh, you're being emotional, who here thinks that's a compliment? We hate hearing it. Or calm down. Is there a better way to get under someone's skin than just to look at them and just in a measured way say, calm down? Because now you've taken on the mantle of reasonableness. But there's a measure of that. Emotion is very, very dangerous, particularly when it comes to actually at any point, but closing, and certainly opening when you don't even have the factual record developed. Be measured. Okay? The other thing here is this. And let's say, from your perspective, what's better? Okay, so I'm going to give you one idea. If you develop the idea, you develop the affinity for it. Okay? You feel stronger about it than if someone's telling you to feel affinity for it? Yeah. Nobody likes to be told what to feel. We're human. It's amazing how much basic logic, common sense permeates this business. Have you ever seen lawyers in close? I mean, you see it on TV. I see it on TV all the time. Where they're just going on and on and on about how you're supposed, and this and this and that. And I'm telling you, and this is the only conclusion that you can draw, and yada yada, and yada yada. You follow me? Who wants to hear that? Let me reach my own conclusions. Give me space, Mr. Lawyer. Right? Give them space. Let them reach their own conclusions. Because their own conclusions, folks, are going to be the ones that are going to work the best for you when they're deliberating. If it's their own conclusions, they're going to fight for their conclusions. If it's something that they were force-fed, it's a much weaker process. It's weak, and it can even be worse. They can be positively turned off by it. All right. Be authentic. All right. And what I mean by that is be true to the record. When you're doing, and I mentioned this before, we can sit here and deal with themes and deal with narratives. But at the end of the day, okay, everything that comes out of your mouth must be supported by the record. It must be. And it must be for two reasons. First, the law requires it, really. I mean, the law gives you, in fact, it's interesting, the law gives you plenty of leeway to hang yourself as a trial lawyer and a judge may not even tell you that you need to be absolutely true to the record. In fact, if the judge doesn't like your case, probably the biggest favor he can do you or she can give you, let you play fast and loose with the facts. And I'm being hyperbolic here. But my point is that when you're being fast and loose with the facts, the jurors will catch on. Okay, they'll be told or they'll know, and your credibility is shot. Or, judges will step in if it's bad enough, as they should. Now, there's a sense to being true to the record here. And I want to try something out with you all. I'm going to go back to your problem. And I don't know how this is going to work out. I'd be actually interested in sensing what you think. So let's go. I'm working through with the jury here, and I'm going through the evidence, right? And you'll recall that there were these emails, right? We have the March 13 email from Blue Forest. That's the distributor, remember, that Carlson was talking to? And he's saying the distributor is actually sending a note to Carlson. Things are really looking good on this end. People really love Pine Lines. If things keep going this way, I didn't give you this as part of the problem. If you're the 1Ls, you know it. But for the rest of the group here, there's an allegation that Carlson, through this new business, tortiously interfered with the contract or the commercial relationship that was that existed between Blue Forest, the distributor, and Timberline. Okay, and Carlson was talking to this distributor, okay, before he left, and so there's email traffic showing that there was actually a growing affinity between the distributor and Timberline, and that they were close to making a deal. And the allegation and the complaint is Carlson jumped ships, and he grabs the distributor for himself, thus tortiously interfering with the commercial relationship between the two. Okay, and there's some emails, March 13, 2025. So I'm working with the jury like this, and I pop these things up, okay? March 13, 2005, things are really look at people about it. And I go and I march through these emails like this. Okay, track me here. Now I'm going to go about it another way with the jury. Okay? So this is the actual exhibit. Okay, so there's a stamp on it. All right? And let's say these are critical points. And so what I do with the jury in close instead is it laptop, Mark? Mark? I lost Mark. Okay, we're going to see. Yeah, there we go. That is it. Okay. So members of the jury, you saw the exhibits. You saw us walking with using these exhibits with Mr. Carlson, yada, yada, yada. And you'll recall the March 13, 2025. There's a big exhibit sticker on here, right? March 13. Okay. We have the distributor, Blue Forest. I'm out of the office, blah, blah, blah. I'll call you. Actually, here. Am I doing the right ones here? There's a point here. Bear with me. I don't think they track. But here's my point. It doesn't really matter. Okay? And you go here, and I highlight. Okay? I go, you can see my hand at work. You got a little bit of my hand. I'm going to use a highlighter. Then I'm going to do this. All right? Question for the group. Okay? And I'm just curious. When it comes to authenticity and communicating to the jury that you're being absolutely true to the record, okay? What captures it? This process, where they see the exhibit, there's the exhibit sticker on it, they've seen it before, and we're highlighting this. This is the actual stuff, or this. Who thinks that this is better? And there's no right or wrong here. I'm just curious. In terms of just authenticity, I'm being true to the record. Really. Folks think that doing it this way lends more authenticity? Hands? Yes? Yeah. I agree. I agree. And I learned this the hard way. I mean, as I'm sitting here, you're going to think, man, this guy made a lot of mistakes. But it was a lengthy trial, and I prepared the closing argument for the partner who led the case. And I had, I don't know, a month or so. I mean, the case went forever. Had a month or so to prepare the slides. And he stood up. We were the plaintiff, and he started marching through the close. Okay? Boy, oh boy, my slides were good. Almost as good as these. I mean, Steve? No, I mean, they were actually, they almost looked as good as Lanier's. I mean, they were boom, 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 boom. And it was just slide after slide, after slide, after slide, after slide, after slide. And I got this queasiness. I'm just thinking, there's a sense of, like, this is all. And then the plaintiff's lawyer, or the defense lawyer, stood up. Just an absolute genius of a trial lawyer. A genius. Okay? And the first thing he said, standing up, he said, I have to give it to my esteemed colleague, Mr. So-and-so. He can make one hell of a slide. And I'm the guy who created them in the background. All right? Well, I'm going to have some to help you. But members of the jury, and he had this southern drawl, we're going to rely on the record. And so as he was going through witness testimony and documents, he took out the actual transcript, and it was basically his show with and he was taking the other transcript, boom, 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 boom. And he had some slides in there. I never forgot the lesson. I never forgot the lesson. In this day and age, when we rely on digital stuff and pictures and yada yada, and we hear, jurors want to see movies and they want to see this and they want to be entertained and there's a human element to it too. They want to see the real you. By the time that I'm done with trials, it's actually a running joke with my teams. My hands, okay, are black, blue, red, green, yellow. Just of all the markings. And because I want to be real. It's got to be me. I'm working with the record. Steve, you were going to say something.
No, I was just going to say, if you put up that slide that was on the
Yep.
That's, I assume I didn't try to compare it. That's the same document, just marked up into a demonic.
Correct.
Okay. So what would be wrong
By the way, I had the dates, and some of the dates went off track, but put that to the side.
The right way I was going to be to have the exhibit label on this document, none of the highlighting, and then build it in the argument with the highlighting and with the, Blue Forest to Carlson and so forth. So you take what's real, and then you build on it to show them what it means. Is that?
Yes, that's actually a fair point, Steve. Did everybody hear Steve's point? He says, and Steve's right. I mean, now actually the mission, when I said to the folks who were helping me with this, is I want you to make this look as flashy as possible, and that was the version we came up with. But you're right. I mean, this is a little over the top, and I've sort of stripped it, a lot of its show and authenticity. Steve was suggesting, look, if you're going to just put it up on a slide, actually have the real document up there with the exhibit sticker so they know you're dealing with the actual thing, and you're just not making stuff up right out of thin air. Fair point. But the overarching point is, mix it up. Mix it up. It was such a sinking feeling. All that hard work I put into my slides, and have this genius stand up and take a swipe at the guy I was reporting to and say, man, he makes one hell of a slide. Ouch. And kudos to him. It was brilliant. It was the right call. So bear that in mind. I'm not saying don't use these, because a picture is 1,000 words and all of that, right? I mean, you have the bullet points, you have this, but don't lose, okay, the genuine article, if you will. Uh-oh, this thing's going haywire here. All right, let me go to one last point here. And this is this. Be yourself up here. I think I may have touched on this earlier. As you're going to see more speakers, and I remember being in your shoes, sitting in your chair, look at some speakers and saying, how on earth am I ever going to measure up? I don't have that, that silver tongue, that gift of gab, and on and on. And the reality is that, I mean, sure, you need to be, if you're terrified of public speaking, and you break into hives whenever you're in front of a group. And I could come up with other things. Okay, maybe being a trial lawyer is not for you. Maybe. Because, look, you can actually work through some of that. I've seen people work through some of that. Believe it or not, I used to be very uncomfortable speaking in front of a lot of people. Not the dinner table, as my son back there will attest to. But here's the point, okay? If you have an affinity for this business, and I assume that some of you, that you have some of it, given that you're here, okay, that's saying a whole lot in and of itself. You're drawn to this. And if you're drawn to it, there's a reason you're drawn to it. And part of that reason lies within your personality. Okay? And so you're way ahead of the game already. Don't fret about not being as eloquent or as showy or as flashy or as... Don't. Be yourself, albeit working with rules, or not rules, but they're speaking techniques that can help you, that can help make you more persuasive. All right? But there's a story here. I was... and before I get to the story, I want to, one more thing. When you're doing your close, don't read from an outline. Okay? Don't. Because when you're reading from an outline, members of the jury, blah, 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 two things happen. Number one, you tend to get monotone. You do. Number two, you're not looking at the jury and engaging with the jury. Part of the thing in closing argument is an engagement with the jury. You are looking at them. You're making eye contact. Of course, you're being careful, right? Remember? Give them their space, but you're making contact. Okay? There is a communication going on here beyond the spoken word. I mean, there's a bonding, there's a trust, if you will. And that can't happen if you're reading from a script. Now, a number of judges out there, particularly federal judges, I've seen a number of them, will basically force you to do your closing behind a lectern. You can't move. And I never quite understand. And they get so, I mean, you'd think you'd be cited for contempt of court if you walk beyond this certain line. And all of the clerks, the courtroom deputies, everybody knows where the line is. And the helpful clerks will nod at you if you're getting too close to the line. The unhelpful ones will encourage you to step over. Anyway, I digress. But my point is, do what you can to engage with them. Because here's what happens. You're developing a relationship with them. Okay? You're more persuasive. You appear more believable. All right? And it enhances your credibility, and you're being more persuasive. Now, question, Luke, how am I going to remember all that? I mean, look, I've been yapping for close to 2 hours. And it's not been, have you seen me read off of a script? Not really. But I prepared. I mean, you know, if you go back to my home office, you're going to see a memo pad with a ton of notes about what I want to convey and the order in which I want to convey it and precise points that I want to mention. It's all there. I used to write my closing arguments back when I was working for David over there. Just the whole thing, verbatim. Verbatim. And then I go down, I break it down, break it down, break it down, break it down, break it down to the point where I stood up for close. I would have a page with some head notes, some highlights, and what they did is they triggered what I needed to say. And okay, maybe you use a little bit more, but don't read. Don't read. And the other thing about it is you want to be spontaneous. There needs to be an element of spontaneity. Because what does spontaneity signal? Starts with a C. Confidence. Certainly confidence. Credibility. You know, what is it? What's the hearsay exception? The dying declaration? Remember, everybody familiar with the hearsay exception, the dying declaration? Why is a dying declaration a hearsay exception? Because people figure when you're dying, you're going to tell the truth. I mean, I think when you're dying, you're going to be pretty spontaneous. It's credibility. It's credibility. It's not canned. You don't want to appear canned. Okay. On the be yourself point, I was up in a case against a preacher. Mark, this is no cut against you. Mark's a preacher, you know. I applaud him. He's excellent at it. But I was up against a preacher. And this guy was just, absolutely brilliant. And did I touch on this story before? About the preacher and the jury personal. I said it to somebody beforehand. Have you all heard it? If you have, raise your hand. If not, don't. Okay. I must have mentioned it to someone else beforehand. This guy, I mean, he was about as eloquent, about as I can't come up with the words to describe it. I was in awe watching him. Okay? And then I'm standing up to do my close, and what you pretty much see what you have here. I was in my blue suit, my white shirt, my darkish red tie, right? And I marched the jurors through, I went through the closing argument, actually pretty much the same as you see here. And sure, I got pretty, at some points, I'd kick up my voice a little bit, and people saw that I meant what I said, and some of the stuff I'd seen in the trial wasn't right, and the jurors understood that I was just being measured out of respect for everybody, but they knew that there was a fire there. I just kept it in check. I was myself. I was true to myself, measured. 3 years later, I'm taking the Green Line, the downtown station. That's the one that takes you up to Shaker Heights. And I'm about to board, and this woman approaches me, and she says, Mr. Dauchot, Mr. Dauchot. And I look at her, I said, yes. She looked at me, and she said, do you remember me? And I said, no, I'm sorry, I don't. Well, she was the foreperson in that trial. And she said, Mr. Dauchot, I have to tell you that it was very complimentary. I mean, I don't mean to, I'm not tooting my own horn, but she was just over the top in terms of how credible I came off and how they believed me and they wanted to go my way. And they just, she was just, it was over the top. And she mentioned the opposition. And she said with a laugh, says, and she called me Luke by the time we were done. She says, now Luke, you didn't have Mr. So-and-so's silver tongue. And she was right. She was right. And this isn't a cut on people who have, who are very good at it. Not at all. That's not my point. My point is that there is no better way to enhance your credibility than to be who you are. With some coaching, right? But be who you are. And the last point is, don't be afraid to make some mistakes. You have to be willing to make some mistakes in this business. Hopefully not case critical. And hopefully you're not put in a position where you can make those. But that's how you grow. All right. With that, I will stop and ask you if you have any questions of me. Yes. Yeah.
Hi. Thank you for the informative talk. My name is Peter. I'm a 2L at Case Law, and I handle closing arguments for a mock trial team. And about halfway through my argument, I see judges' eyes just glazing. So I was kind of wondering how you go about managing the jury's attention and kind of making sure they listen to every bit of your closing argument as well.
Yeah. All right. So, look, it's happened to me. And so what you do is, all you need to do, you talk about blah, blah, blah. Now, I want to point out one thing. And then you kick up, and then you just back up. You use your voice. You use your voice, and if you can walk around the courtroom, take a couple steps towards the jury box, raise your voice a little, not in an offensive way. You don't have to stare at them. You don't want to stare at the one who's dazed off, but just, there's a way to do that. And the other one quick point too is you don't want to get in the business of trying to read the jurors too much. I learned that the hard way. I was in Minnesota in a case, and I was working on my clothes with somebody, and there was fire, brimstone, this, that. Stood up in front of the jury, and they were like half asleep, half out of it, and I'm like, oh my Kate, we're toast. They're not buying to this stuff. I put all the fire, the brimstone aside because I didn't want to be presumptuous. And as it turned out, they returned a verdict, everything we wanted in less than an hour. In fact, they said no to the pizza that they had ready for lunch. But the point being, be a little careful there too. You want to make contact, you want to engage, but don't try to read too much, because a lot of them just put on a stone face because they don't want to look like they're rooting for you. And I've heard that said too. Steve, you had a question.
Yeah, so this is tremendous. Largely geared to juries?
Yes.
Is there any one or two things that stand out that you would say different if you're arguing to a judge or an arbitration panel?
Well, let me say, for an arbitration panel, I don't do a whole lot of arbitrations. I've done some. I've done plenty of bench trials. What I won't do with a bench trial when I'm dealing with a judge, I'm going to assume that the judge knows a whole lot more than a juror does, for example, on instructions of law. I'm not going to sit here and pontificate about that, right? And the slides that I put up on the patent boundary and all that, putting that up for a federal judge is positively insulting, right? I mean, they're like, okay. So there's that. I think that when it comes to exploiting credibility issues, judges and arbitrators for that matter are, I mean, with a jury, think about it this way. If you're going to make a credibility point, and this is a completely different topic, but I fish for credibility points on stuff that is not necessarily at the heart of the legal merits of the claims. Sometimes you have to get peripheral. Okay, and what I mean by peripheral is, there's a saying, right? Once a liar, always a liar. And if you can make it relevant enough, tangential, okay, relevant enough to get in under 402, 403, okay, you make a point, the jurors get the fact that the witness is fibbing, and then they're extrapolating and saying, fibbing there, fibbing always. That type of dynamic with the judge, if you get too peripheral with the judge is going to lose patience with you real fast. You need to just stay on that highway. You need to stay super focused, because you're dealing with somebody who knows this record a lot better than a jury. I mean, look, you have a trial judge. The trial judge gets what? Trial briefs. In some courts, you have a new judge to try the case, like that used to be, in some of these state courts. But in federal courts, it's the same judge. She's lived with the case. She's seen all the briefs. She's eliminated. I mean, magistrates do it. Magistrate judges do it now too. But so, there's that element. And so that with that, Steve, I'm being probably too wordy here, but with that knowledge, okay, comes an impatience with touching on some of the more tangential stuff that in a jury context where the jurors don't have the familiarity with the record that a judge does, the tangential stuff, particularly if you're scoring credibility points, and there may be other things too, they tend to be more effective. Put it another way, think about it. I say jurors deliberate or they get this evidence in a fog. To be sure, there is an element of fog with judges. I've had judges voice in bench trials exasperation. When we're getting into some of these patents, like ANDA issues and pharmaceutical drugs and stuff like that, and it's like, and then what the judge does is just tunes out. But you know what the judge can tell you? Is just brief it. My clerks will do the heavy lifting and the thinking. So you see, it's a completely different dynamic. It's different. And so when you get to persuading a judge, I mean, sure, narratives are important, themes are important, because they're human beings. They need to get the big picture. But Steve, I think certainly arbitrations, it's a completely different game. I think. Others may differ with me, but I certainly think it is. And even bench trials. But, obviously in bench trials, you have to be credible, right? You have, and even there it's even more important, because a judge isn't going to, but yet certainly here this evening, I was focused on the jury trial, which, by the way, contrary to what I've heard some suggest, the Seventh Amendment is alive and well with all sorts of cases. And you're talking about tort cases, the stuff that Lanier does. You're talking about business cases, and I think Mark probably does business cases too. I suspect he'd be highly effective. All sorts. So, anyway, but does that answer your question? Yeah.
Mike Unger, nice to...
Oh, hey, Mike. Thanks for showing up. He's a heck of a trial lawyer, by the way.
Thank you for being here. And this is a great presentation. I just want to take a moment to thank, for those of us that did not matriculate at this great law school, thank you to Case Western Reserve University. Thank you to Steve Kaufman, our benefactor. I was at the Lanier presentation. These are phenomenal. Here's my question. continuum from the point of engagement until the time trial commences? When do you start thinking about the closing argument?
Well, Mike, that's a great. I will. There are two things, right? Conceptually, very early on in a case, where I get a case, and as we march into discovery, Mike, I'm not thinking about closing as such, but I am thinking about themes. I am thinking, why is this jury going to like my case? Why is this jury not going to like my case? And that's the initial concept, right? And then it becomes, you start there, and then in asking yourself that question, you're starting to come up with themes. You're starting to come up with narratives, right? Now, the process of actually drafting the close, I typically do that, if I can, a couple months ahead, like in real detail, if not even a little earlier. I start the process very early on, and it changes, right? It changes. But Mike, by the time I stand up and do it, it's like reciting the Our Father, you know. I mean, it's there, and that's the other thing with not having notes, or with not being tethered to an outline, right? It's like a ball and chain. Particularly if you're going, particularly if you're going second. Part of what you're doing is you're looking at the dynamics. You're seeing, what did the jury really respond to? What did they not? And you're eyeballing the jury, and your brain's going haywire. You're taking all this stuff in. And maybe you got to make some adjustments, right, Mike? And you make them, I'm sure. You don't know. And so you have to make these adjustments. Obviously, the guts, the core may not change, but if you're tethered to this outline, and you have it all typed out, and you're going to go blah blah blah, you can't adjust. So, anything else? All right. Well, look. Thank you, everybody, for being here. All right.
Thank you so much, everybody. So practitioners, if you have your CLE forms, there'll be a spot to drop those off. But please stay and have a short reception with us before you take off for the evening. And thanks so much for joining us.